So we're up to Module 7 here, which is the legal system. And I must say, I've had quite a bit to do with the legal system in various forms, but I watch a lot of legal procedurals on TV. It's just, a lot of them are quite accurate. So cases are tried. A jury is people that listen and decide whether you are guilty or not guilty. The plaintiff is the person who is complaining about something, and the defendant is the person against whom some complaint is being made. So this comes from common law, which is based on precedent from previous decisions. So when you make a decision in court, a future trial can refer to the previous decision and say, my case is like that case, and try to influence the result based on that. All right, so there's 3 bodies of law in the U.S., constitutional, statutory, and regulatory. And if you've been following the Trump prosecutions, which I have, it's very interesting. It's a very interesting study in all the nuances of this stuff. So constitutional and federal law has to do with the relationships between the branches. Statutory law is written at national, state, or local levels, and regulatory law is the part that the Project 2025 under the Trump administration, especially Steve Bannon, promised to get rid of. This is where you put in a regulatory agency like the Department of Food and Safety, and they can pass regulations requiring you to not put certain additives in food, and that doesn't have to go through Congress. That's not a law. They can pass regulations like you have to get a driver's license, and if you commit certain violations, you lose it, and all those become things people have to obey that are not exactly laws, and that's regulatory law, like environmental protection and the air traffic control and so on. And the Republicans currently want to get rid of this, which would create a certain degree of chaos, certainly. So anyway, the court system works like this. You have, at the bottom, you have specified courts that work for certain things like tax and bankruptcy and such, and then you can appeal things if you want to higher courts. You go to circuit courts of appeals, and if you don't like that, you can appeal to the Supreme Court. And that's what we're watching happen a lot with Trump and his gang. All right. So those are the appeals courts. In Canada and other parts of the United Kingdom, you can ultimately appeal to the Queen, or now I guess the King. But we don't have that option. The highest thing we have is the Supreme Court. And right now the Supreme Court is hated more than it has ever been. Its approval rating is down like 15%. It is extremely obvious to everybody that the Supreme Court is currently extremely corrupt, blatantly taking bribes, blatantly making political decisions, blatantly making decisions based on absolute lies. Several of their recent decisions have been based on completely false statements they make in their final judgment. So it's a bad time because there is no appeal above the Supreme Court. And yet the Supreme Court is going through a period of considerable distrust and corruption. However, they've been here before with the Dred Scott decision and many others. There have been times in the past when the Supreme Court was making awful decisions that would later be overruled. But it is a troubled time in this country in that regard. It's funny, the federal courts are in Washington and apply to the whole nation. And we talked about the Supreme Court and U.S. district courts, all right, state appellate courts. We talked about these things in general, and then these limited jurisdiction like juvenile, traffic, family, and specialized areas. So all that is, you don't need to know much detail about that for the purposes of being a forensic expert, which is what we're talking about here. This is getting now more to what's more directly relevant. So when you go to court, first they select a jury. The prosecution and defense can both exclude witnesses, and the judge can exclude witnesses who appear to be biased, eventually settle on them. Then you have preliminary instructions and opening statements, then the testimony of witnesses, and in particular, you have expert witnesses. Now, in court, a witness can only talk about what they directly saw. I saw this thing happen. If they heard somebody talk about something, then that's just a rumor, and that's hearsay, except for the expert witness. The expert witness is the only person who has the ability to turn an opinion into evidence. The expert witness can say, I examined this thing and I formed an opinion, and here is my opinion, and that opinion may be weighed as evidence with the jury, who will then decide how much they trust your expert based on their expertise, how many degrees they have, what training they have, how impressive they look in court, and so on. And so then, all right. So voir dire is the process of selecting a jury. In some cases, you have to sequester a jury, and another process that's becoming more and more necessary in the current climate is the Trump jurors are now being kept secret, so nobody can see them. This is because anybody that serves on a jury judging Trump is subject to death threats and people coming to their house to harass them and threatening to kill them and their family and everything else as the Trump fanatics try to punish them for daring to question him. So more and more of the juries in the Trump trials are being kept completely secret. So nobody will ever know who they are. And the judge said, after this is over, you will have the right to go to newspapers and sell books, but I strongly recommend that none of you do that. You will never want anybody to know that you served on this jury for the rest of your life, which I think is the correct precaution to be taken. Let me check for comments on the Twitch, which will be here. All right. All right, good. All right, so you have deliberations where the jury, after they've heard the evidence, goes into a private room and reviews it, and then if they can't reach a decision, it's a hung jury. And then another big issue is criminal versus civil. Criminal charges are prosecuted even if there is no victim. For example, murder. Somebody gets murdered, there may well be nobody to complain, like no family left behind, and yet the state will still prosecute someone for that crime because it's so serious. That's a criminal charge. You're prosecuted for it even if there is no plaintiff complaining. But in civil trials are only about money. Somebody doesn't go to prison, all they do is pay money, and somebody has to step up and be the plaintiff. This is one of the cases that I was mentioning earlier with the Supreme Court that is outrageous. The Supreme Court wanted to pass a rule that it was okay to discriminate against gay people, so they accepted a case where someone claimed that they had a website business where they were making marriage websites, and a gay person asked for the website, and they wanted to refuse on the grounds that they disapprove of gay people. And it came out that this is all completely false. That person never started the business. They never had a customer like that. None of this ever happened, which means that you're absolutely not allowed to take it to court. Courts are not allowed to consider a theoretical case of something that might happen. They're only allowed to consider a real case where you have a real plaintiff and a real defendant, but the Supreme Court just ignored that and ruled on it anyway. That's what Congress is for. Congress is allowed to pass a law without having an exact person complaining. They're just allowed to decide, we think the people want this. But the courts are not supposed to do that, but they are doing it, and there appears to be nothing anybody can do to stop them. In principle, you can impeach and remove the Supreme Court witnesses, but as we've seen, that's quite ineffective in our system. Anyway, you can also have depositions. Instead of testifying in court, you are just interviewed and recorded out of court by attorneys, and then that tape is played. There was a famously disastrous deposition from Bill Gates when Microsoft was sued for antitrust over Windows 98 and Microsoft Active Desktop. He made a deposition full of obvious lies and arrogance, and it made him look very bad in court and went against him. So civil trials are generally over money, like I say, and by the way, they're also at a lower case. In a civil court, where you're arguing over money, all you have to win is by the preponderance of the evidence, which is it's more likely than not that you're correct, and then you will win. In a criminal case, you have to prove beyond a reasonable doubt, because it's much more serious. Somebody goes to prison. So, all right. So the First Amendment is one of our protections. The original Constitution, when they tried to form the United States of America, they tried to get the 13 colonies to agree to form a union on the Constitution, and they would not agree because the people had serious arguments that the government that was proposed would be abusive and harm the people the way the government of Britain they were rebelling against would, and they immediately added the 10 amendments to try to improve the Constitution, which was necessary to get the original 13 colonies to agree to join this government. And so the First Amendment says they can't establish a religion and they can't prohibit freedom of speech or of the press. This is important, although not directly relevant to forensic work. What's much more important to forensic work is the Fourth Amendment. You have a right against unreasonable search and seizure. So the government can't just barge into your house, search it, and find out you've been doing criminal things. They have to get a search warrant and go before a judge and have some evidence, reasonable evidence, to justify invading your privacy like that. They need to have warrants, which is real important. All right, and a lot of special cases will come up later on. One issue here is the fruit of the poisonous tree. If you get information from an illegal means and then use it to investigate and find more evidence, all of that evidence is inadmissible in court. It's all fruit of the poisonous tree. However, there is a disturbing process underway now the NSA is allowed to spy on foreigners with no restriction. Foreigners who are not citizens of the United States have no privacy protection at all. The Fourth Amendment does not apply to them. So the NSA just wiretaps their phones and reads their emails and stuff all the time. But they're only supposed to do it for national security issues. However, if they wiretap their phone calls, they will also get what the citizens say who are on that call. And then they hand that information over to the FBI, who will then try to prosecute those people for committing crimes, even though the FBI is not allowed to wiretap those calls. So there's a thing called parallel reconstruction, which actually happens in U.S. courts, where the FBI will make up a fictional story saying we had a confidential informant who told us about this, when none of that is true, to make up an apparently legal reason why they have this evidence, which they got from the NSA. I don't understand how any of this is accepted as legal in court, but it is. And it does seem to be a dodge around the fruit of the poisonous tree. All right. And there's motions in limine, or what you have if you want to suppress evidence. You claim that this evidence is not relevant or it was obtained illegally or something. You make this motion to suppress it. So search warrants, an important part for us. You can't investigate something. You can't gather evidence unless a search warrant allows it, and search warrants are always limited. You don't just say you're allowed to investigate somebody. You say you're allowed to go to this location and seize these kind of documents and papers and computers and so on, and not these other ones, which is why I mentioned the first thing you do when you get a Windows machine to investigate is you look in the registry for the USB store key, and you find out what USB devices have been connected to that computer, and then you tell your client to write another search warrant to seize those other devices that were connected to this computer and probably part of it that you didn't know about until then. Let me check for comments. Okay, good. All right. Anyway, all right. So there's a lot of cases about that, and there are certain conditions under which you can search without a warrant. Since the Patriot Act, after 9/11, anything having to do with terrorism, they're pretty much allowed to ignore all these rules and investigate things as being essentially an emergency. You can also consent to things. Like a cop can stop your car and say, do you have guns or drugs in the car? They commonly ask, and they'll say, will you let us search the car? And if you say yes, then you've agreed and they're allowed to search the car. You can say no, however. All right. And there's knock and talk without sufficient evidence. They can try to convince you to come in. There's plain view doctrine. If there's something they could see without entering your home that's just sitting out in the open, then they can claim that it's not protected because there was no reasonable expectation of privacy. And this gets into the really difficult cases of your cell phone, your emails, and so on. For example, if somebody has a ham radio and they talk on the ham radio and send unencrypted radio signals out, do they have a reasonable expectation of privacy for that or not? And I've certainly heard a lot of arguments about this. It's not incredibly clear. All right. So a lot of cases about that. A stingray is a digital surveillance. Stingrays are devices, the police have them. They drive a truck in your neighborhood. They turn on this device, and it is a cell phone tower. When you make phone calls in the neighborhood, it will have a stronger signal, so you'll connect to this tower, and then it'll forward your phone calls. So that's the way they wiretap cellular telephones. And therefore, they cannot get just the one they have a warrant for. They'll get all the ones in a region, and then they have to say they have ignored the other ones. There are apps you can put on your phone to try to detect these for Android. I've seen them. I don't know how accurate they are. All right. And then there's GPS tracking. There was a big expose that came out in the New York Times on the front page today saying that your car is keeping track of everything you do and secretly sending it to insurance companies who are using it to change your rate without people knowing about it. And that may or may not be legal, but it does bring up the really big issue that all these requirements only apply to the government spying on you. Private companies are totally allowed to spy on you with apparently no restriction. So if you put an app on your phone, the owner of that app gets all kinds of data from your phone, and they can use it for any purpose they want and sell it to other people and sell it to data brokers and resell it, and it's worth a lot of money to them. And there seems to be no privacy restriction at all on that in America right now. It's a big issue. So this gets you to the other strange issue, which is even if it's illegal for the police to gather data about you, couldn't they just buy the data from the data brokers the way advertisers do? And some police departments are doing that, and it is currently working its way through the courts trying to decide if that's legal or not. All right. So there's traffic stops and so on. And then there's the Fifth Amendment. which says you can refuse to testify against yourself. So that's in 6, which I don't think matters to us that much. Now we get down to the legislation that applies to us more directly, like the Wiretap Act. People who commit computer crimes, unfortunately, there are only a few laws that designate computer crime, and all of them are decades old, mostly from before the internet, and they don't apply very well to modern situations. The Wiretap Act says you're not allowed to intercept a wire, oral, or electronic communications without a wiretap order. And this move was amended by the Electronic Communications Privacy Act to include transmissions from a computer. But that's from 1986, so that's before the internet, and so it applies in a strange way. But anyway, that's problematic. Then the Foreign Intelligence Surveillance Act. This is the one where they're spying on foreigners and therefore allowed to do pretty much anything because of the Patriot Act, including the highly disturbing national security letters. Since the Patriot Act, they are able to order any provider, like an email provider, to hand over the data from someone and not tell them that you did that, and in fact never tell anybody anything. You can't even talk to your attorney to decide if you can sue or anything. You can never talk to anybody about it at all. That's what it says, and that is enforceable, and therefore there is no way to review these things, which are secret, and see if they're being abused. So it is troubling, but it is definitely going on. And here's the one which most computer hackers are prosecuted under, the Computer Fraud and Abuse Act. I've been accused of breaking this one. Anybody that does any security research ends up accused of this sooner or later. I've never been taken to court over it, but this is the one which says you have done something that exceeds your authorization on a protected computer. The original plan was protected computers would be computers used by major insurance companies and the government and such that distributed data across state lines. But now that we have the internet, essentially every computer distributes data across state lines. So any server is a protected computer. And what it says is that if you send a request to that computer and you gain information that you are not authorized to have, you have now broken the Computer Fraud and Abuse Act. So this would mean, for example, right-clicking and viewing the source code of a web page and seeing a vulnerability could be arguably a violation of the Computer Fraud and Abuse Act. You have learned something that they don't want you to know, even though you didn't cross a barrier or in any way break into anything. So that's why it's vague and unclear how it works, and that's why you have to have a lawyer and you have to defend yourself in court and cooperate with your lawyer. You will make arguments that what you did was reasonable, which is what I would do if they'd taken me to court, and the other side may make other arguments, and then you fight it out. There is no such thing as having no legal risk in America. Everybody gets sued for stuff all the time, so you just have to accept what is an acceptable level of legal risk, just like there are other risks, like hacking risks and physical security risks.
The journalists look at the web source code.
Which one?
The journalists, the newspaper journalists.
Yeah, newspaper journalist, yeah.
Yeah, he used the web-based source code to do to look at do some research. And
yes.
And they got sued and the court go up.
Yes, I've heard of quite a few of those. Quite a few people have attempted to use the CFAA to abuse people who are doing very harmless things like looking at source code, and those cases often get thrown out. But the point is, you are at some legal risk. There's an argument that you broke the law and you have to defend yourself. And people who are incompetent to defend themselves or too crazy to cooperate with an attorney can get in trouble. And at some point, that's why it's vague. I was not pleased when I went to talk to the head of the FBI, Computer Crime Agency, and he said, "Look, all your researchers, we know that you're breaking the law doing all your research, but you don't have to worry because we only prosecute the real bad guys." So that's where we are. It's not like there's a clear line and we know what side we're on. It's like a value judgment. Are you helping the world? Are you a good guy? And so that's a pretty fuzzy, vague line. It's not reassuring, but that's where you are. There's a Corporate Espionage Act too, and other ones like computer trespass and so on. And I mentioned the Patriot Act. This was our response to the 9/11 terrorists, which made people much more interested in catching and prosecuting terrorists and much less interested in privacy. So it basically lowered the Fourth Amendment protections very much for cases involving terrorism. All right. And the DMCA is another big one, passed under the Bill Clinton administration to make it possible to do business on the internet. This is probably the most useful one for companies because it has provisions that make it easy to get things done without going to court. The DMCA was intended to make it possible to put copyrighted things on the internet and protect them. So this is what all the movies and music industry use to attack people who make extra copies of music or download it from pirate sites and such. And the part that's extremely useful to them is if you don't like anything on the internet, all you have to do is send a DMCA takedown notice to the provider that is hosting it, and they must either, if they leave it up, they will have to defend that it is not stolen property, but if they take it down, they don't have to defend it. So in practice, 90% of everybody will just take anything down when they get a DMCA takedown notice without asking any questions, because they just don't want to take the risk. And therefore, it's used greatly to just take down content, even when the person taking it down has no legal claim to it at all. It's an easy way to take things down in practice. All right. And so anyway, to decide if evidence is admissible, there's Fry, which says you must be based on science that is not experimental, and these things change, like polygraphs have never been accepted. Fiber analysis under a microscope was accepted until last year when they decided to no longer accept it, deciding it was insufficiently scientific and so on. The Daubert test says you have to perform benchmark testing on your hardware and software tools. So you'll see the forensic tools, some of them claim they've been tested and calibrated and have rules to do that and so on. So you have, this is what the expert witnesses, like us, have to do, is pass these tests. And the important thing is testimony that is not firsthand is hearsay, but digital evidence is not hearsay, something you might find in a log. And opinions of experts count as evidence. So you'll have to have a report. Typically, it will state all your opinions and the basis for them, the facts and data, exhibits, the witness's qualifications, listing all publications, list of the other cases you've been on, a statement of how much you're being paid. These are all things that will be available so people can look at that and decide whether they trust you or not, which is the main thing you're doing. The main purpose of the expert witness is to convince people that you are trustworthy, and therefore they will rely on your opinion. Let's see, the Patriot Act is an excuse to break their own laws. Well, yeah, you can say that, yeah. But of course, they're supposedly doing that to stop terrorists. That's the idea. But there's not much in the way of any oversight to see that they in fact use it only on terrorists. All right. And so there's the federal rules of evidence and hearsay. We kind of talked about that already. Best evidence is useful. This is why you never examine a computer in a computer crime case. You take an image of the computer and you lock it up in a safe because you preserve the original computer to take to court. This is the device that was used to commit the crime. That is best evidence. This is what you want. You want to have the actual thing that was used to commit a crime. This is the gun. This is the glove. That's best evidence. If you have some kind of copy of it, it's not best evidence. It's less valuable. That's why you never study a computer directly. You always study a copy of the computer. There's another good reason for that. You have to provide a copy to the defense and a copy to the prosecution. And then they look at the MD5 hash and they know it's identical. And then you know it's been fair. Both sides had all the evidence. All right. The California Consumer Privacy Act is modeled on the European Privacy Act and therefore limits, says you have the right to remove your personal information from the internet and limit the sale and so on. This is the first attempt to have a Consumer Privacy Act in America. As I mentioned, private companies are spying on you to an unbelievable extent and selling this data over and over and over. So the data brokers know all about you, what possessions you have, where you go, where you work, and all sorts of things. And more and more people are beginning to get worried about that. But California has gotten worried about it first and passed the CCPA. I'm not sure how much good it's done, but it's done something. Europe is way ahead of us. The European privacy regulations are much stronger than American ones. So we'll get in data privacy. Europe passed the General Data Protection Regulation several years ago. And the only immediate consequence of this is every website has to pop up a box saying, we use cookies to track you, and you have to agree to see the web page. That's one of the consequences of this. But one of the rules in Europe is you can only collect data if someone agrees to it, and then you can only use it for the purpose you told them about. This is not true in America. They can collect information about you so you can use Gmail, and then they can sell it again to other people who will resell it and resell it to use for other purposes without telling you, and that's legal in America, but it's not legal in Europe. You also have the right to be forgotten. You have to access your personal data, amend incorrect data, and so on. You have, and the big tech companies all tried to claim that this was impossible, it was too expensive, it was too difficult, but when Europe passed a law, they did it. And California passed a similar law, and so it may spread through America if there's a motivation to have more privacy laws here. So far, it's very difficult to pass any internet regulations in America because the right and the left can't agree on it. The right feels like they are being oppressed when disinformation about vaccines and stuff is taken down, and their idea of protecting internet activity is very different than the left. The only thing they all seem to have agreed on lately is to ban TikTok. So, for whatever good that will do. And although Trump met with someone who apparently contributed to his campaign and then totally reversed his position and now is pro-TikTok, although he was the guy that originally wanted to ban it. So anyway, that may not even happen. All right. So that's the GDPR, limiting what information is collectible in Europe. And there's also privacy legislation in Asia. China has the greatest restrictions, of course. They greatly limit the internet. With the Great Firewall in China, there are a lot of restrictions, and the government monitors what people do, much more than America. And India has a privacy law of some sort, but I'm not sure how much good it does. I know there's an incredible amount of corruption in India. I spoke to someone who fled India and moved his business to America because he was very unhappy at the extreme corruption of the business community there. But anyway, they do have some privacy laws. It may do them some good. Let me touch Twitch. All right, I'm going to stop the recording.